Chair now recognizes the gentleman from Arizona for 5 minutes.
Thank you, Mr. Chairman. Sir, is it the policy of your office for U.S. attorneys to use prosecutorial quotas?
I'm sorry, I'm having a little difficulty hearing.
Okay, I'll get right on top of this thing. Is it the policy of your office for U.S. attorneys to use prosecutorial quotas?
To prosecute?
Yeah, do you have any prosecutorial quotas system in place?
No.
None whatsoever. That'd be anathema to your office then, right? I mean, it's not a policy. So would you
we,
be...
We don't, correct, we do not have quotas.
Right. And so would it be consistent with that when you have a prosecutor said that they're going to he wants to prosecute at least 2,000 people who are alleged to have committed a certain type of crime?
So look, I think you're referring to the January 6th question.
I'm just asking you, would that be consistent with your office's policy if somebody said we're going to get up to 2,000 people on a particular crime? Is that consistent with your policy?
I think what that U.S. Attorney was referring to was a prediction for how many more cases would still be brought because the court had asked how many more people have been
filed a letter with the
identified.
court saying that we're looking at upwards of 2,000. We've got 1,200 more that we think we're going to get. So you don't do that for anything else, right? So you don't have anything like tax fraud. You're not saying, okay, we're going to have so many people that we want to get for tax fraud, so many people we want to get for lying on federal firearms applications.
If a court asks us what the likely workload will be based on prosecutions and investigations that are pending, the U.S. Attorney is obligated to respond.
Did you guys provide any reference of the number of people you thought you would prosecute who were involved in the 2020 summer riots of the burning of the Portland courthouse while there were still people inside those courthouses? You didn't ever file with the court or anything, say, oh, we think we're going to have another 300, 400, whatever it may be, because you didn't file those charges, did you?
I'm sorry, I'm not following. I believe that
I'm sure you're not.
The number that you're asking about was
Let me ask you this question.
objection that the court had asked the U.S. Attorney to make.
Let's switch topics. Maybe this one would be easier to follow, I suppose. Is it the policy of the DOJ to provide advance notice to subjects before conducting a search for evidence?
It totally depends on the circumstance.
If the circumstance were that you had a guest house where the U.S. Attorney, Deputy U.S. Attorney saying, well, we know that we suspect there's a lot of evidence there, but we're not going to really follow that up. And calls the attorney from the other side saying we were going to do a search warrant. Would that be consistent with your policy?
Okay, again, I know this is no hypothetical, and I don't know the facts of this case, and I don't know what happened, and I believe the events you're talking about, as reported in the press, occurred under the previous administration. So no, that event didn't happen in the previous administration. Let's talk about that. I mean, you keep saying this happened in the previous administration. But let's talk about this for just a moment. You keep saying, I don't know what happened there, but I'm going to opine when it happened. Do you see the fallacy of that, the inconsistencies? I don't know when it happened. I don't know what happened because I'm not involved, but it happened under the previous administration. That's so logically fallacious. I'm sorry, I'm not following what's
I know you're not following. So the question is, you've got one of your deputy U.S. attorneys calling the attorney on this side saying, look, we're going to go to these two places, probably go in the next couple of days. And, of course, then ultimately the search warrant is called off. I just want to know, is it consistent to call up people where you know that they've got boxes of information, or you suspect they have boxes of information? That's why you got the warrant. That's why you're going to go look. And you give them a heads up so they can move those boxes of information. Would that be consistent with DOJ policy?
I'm just going to say again, you're asking me actually to comment about allegations in a particular case about which
No, I'm not. I'm
context.
asking you, is that consistent with your overall policy? Forget Delaware and what they did and that they actually did that. Let's just talk about generic policy.
I'm sorry, I thought you were asking about Mar-a-Lago. I may not have understood then. I'm sorry.
Oh, yeah, la-di-da. So when we're talking about this, when we're talking about your general policy, is it your policy? Is that acceptable when you suspect that there are movable items to call up and say we're gonna be there to look?
Yeah, there's no policy on this question. The strategy and tactics to be used to preserve evidence are left up to the investigators and offices on the ground. Sometimes it would be a serious mistake to call up. Sometimes it would not.
And here, once again, you don't know what happened in the Hunter Biden case because that's somebody else is doing it. But you can be sure of the timing of when all this took place. That is one of the biggest oddities of your testimony today. I yield back to the gentleman from Colorado.
Gentleman's time has expired.